Okay, good afternoon, everyone. Welcome to another New Jersey Constitutional Republicans virtual conversation. And it's my great privilege today to have my good friend, Mr. John Gentry, who's running for state senate in the great state of Tennessee. John, welcome to the program. Great to see you again.
Thanks for having me on, JR.
John and I got familiar with one another a few years ago. I did some research and a subsequent video on the abuses being done to American citizens in the family court system. And I gave about a 10 to 15 minute video presentation. And some of the information that I was able to use, I got from John, who is an extraordinary legal mind, as well as a CPA and a Marine. But I don't want to give your bio away. So John, please give us an introduction on your, give us a little bio on your background.
Sure. I was a Force Recon Marine for 8 years, and most people don't know what a Force Recon Marine is, but people are generally familiar with like Navy SEALs. And so the Force Recon Marine would be like the Marine Corps equivalent of the Navy SEAL. So I used to jump high altitude out of airplanes, full combat equipment, lockout of underway submarines, that kind of stuff. And I served a lot of time overseas, and I lost friends, during service. And it is because of that I am committed, as well as the sacrifices that have been made to establish and preserve our Constitution, that those sacrifices not be in vain. In the words of the Gettysburg Address, that we here highly resolve,
right?
These shall not have died in vain. So that was that was the foundation for me. And as a Marine, pursuant to United States Code, I think it's Section 5, I swore an oath to defend the Constitution. And there is no stronger bond amongst men than an oath. And so I adhere to that oath, and that oath did not end with my service.
That's right.
After the Marine Corps, I went to the University of Maryland. I graduated in 2.5 years, cum laude. I'm a hard worker, so I completed my undergrad studies in 2.5 years, graduating in the top 10% of my class. So I'm a hard worker.
Doesn't surprise me.
And you mentioned the family court system. They're rife with corruption, and that was my first introduction into corruption and into politics. And I took some bad state actors as well as bad actor attorneys. I took them in 2 cases to the Supreme Court of the United States seeking justice. And I found that there is no justice in our courts, especially, when you're going after state officials, particularly judges or attorneys. And I also became aware of the atrocities that are being perpetrated against the people. Most recently, Mr. George Floyd, that these protests are happening across the country as a result of. And the atrocities that happen in family courts and that happen with child protective service cases. And so I just became compelled that there has to be a solution. So I did my research and dug into the Tennessee archives looking for the solution. And what I rediscovered is the right of remonstrance. It is our most powerful constitutional right. And so to further defend this right and to have a stronger voice, I announced my candidacy for state senate here in Tennessee.
Right.
And so I'm running for office here in Tennessee as a constitutional Republican to restore a proper form of government that is in open violation to the Tennessee Constitution. So that's my bio, kind of long.
Well, no, it's great, John. It's a great background. And just let me read one of the statements that we like to tell everyone and inform our audiences is that the New Jersey Constitutional Republicans are an equal opportunity provider for all candidates and representatives, regardless of who, what, or where they are located. Our purpose is to educate and inform. Anyone is welcome to participate in the New Jersey Constitutional Republicans virtual conversation, which is a new format for us, and all are welcome to participate. John, what I would like to do is to define a few terms and then let you speak to those terms. You've already mentioned one of them, but I'd like to talk to the people and let them know that we're going to be talking about the right of petition, which is expressly set out as the final clause in the First Amendment. And it says, Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. And this is from the First Amendment. The petition is the right to ask government at any level to right a wrong or to correct a problem. Now, the New Jersey Constitution, Article 1, under Rights and Privileges, Clause 18, says that the people have the right to petition for redress of grievances, as the First Amendment says. Now, the history of the right of petition arises from 1215 Magna Carta. In 1669, the House of Commons resolved that every commoner in England possessed, quote, the inherent right to prepare and present petitions to, quote, in case of grievance. In 1791, when the Bill of Rights was implemented and the First Amendment was added to our United States Constitution, stated the right of petition at that time. And interesting too, I wanted to add too, John, I got this from your website, that from 1830 to 1840, petitions against slavery so overwhelmed Congress until the House eventually adopted a rule prohibiting anti-slavery petitions, repealed 5 years later at the urging of the great John Quincy Adams. Now, that's the right of petition. Now we want to look into the word remonstrance. Now, the Merriam-Webster definition of remonstrance is an earnest presentation of reasons for opposition or grievance, especially a document formally stating such points. Now, the Tennessee Constitution, John, which you're well aware of, Article 1, Code 23, clearly states that, quote, the citizens have a right to apply to those invested with the powers of government for redress of grievances or other proper purposes by address of remonstrance. Now,
let me stop you there. That's actually incorrect. That last phrase has been unlawfully altered, and I'm fighting this in the Tennessee Court of Appeals and the Tennessee Supreme Court. It actually says by address or remonstrance. They changed one letter and they changed the meaning of that last phrase, and they stripped us of our right to address the government. And that's very important to me. We have a choice. We can address them. Sit down, sir. Sit down, General Assembly. I have a protest here, and you need to listen to me. And that is powerful in the Tennessee Constitution, that we have a right to address them. And it's in Kentucky, it's in Texas, that we have a choice to address them. And I'm not familiar with New Jersey, but I encourage you to look at that.
Well, that's what I did look that up, John, and all I could find in our New Jersey Constitution would be in Title 40 under municipalities and counties, and that's 4074-5 that says remonstrance against ordinance, petition, reconsideration, referendum, vote required for adoptions. So that doesn't have the broad application that the Tennessee statute has.
Well,
Would you say?
You're looking in the statute. We need to look at the New Jersey Constitution. And
well, that's what I did. And I didn't find the word remonstrance only in the statute, not in the Constitution.
But it says you have a right of petition, I'm sure. They all do.
Yeah, it does. Right. Under Article 1, Rights and Privileges, Clause 18, it says the people have the right to petition for redress of grievances. However, the word remonstrance is not in the New Jersey Constitution.
Yeah, well, that right, a petition is seeking favor. A remonstrance is a formal written protest against unlawful conduct of government officials or government policy. That right is inherent in the First Amendment of the United States Constitution, regardless of whether it's in the New Jersey Constitution under the Supremacy Clause.
Very good. Well, that's good to know. And this is, now I want you to talk about a little bit about this because in the state of New Jersey, there's a small window that's given the citizens to where they can actually go to Trenton, and they usually the information on when they can go before a committee before legislation gets out of that committee to speak their mind to propose legislation is very, very small window. And it's usually done so quickly that most people can't get up there to voice a grievance or to give a right of petition. So that's the one thing. And then the other thing, what we're doing in New Jersey is we're having lawsuits. We're suing the governor for the edicts that he's imposed upon with the coronavirus. So some of the executive orders he's had and telling some people they're essential employees, other people are not. Some businesses are allowed to run and some businesses are not, yet they sell the same products. Just a lot of different abrogation. Now the Democrats want to borrow more money. They actually want to create a property tax, a new property tax to pay for the debt as a result of their shutting down the economy. So these are the only means by which we have to redress or to remonstrate, if you will. Now, what do we need to do? What can we do more?
This is the perversion of our form of government. Is these attorneys and these attorneys in black robes pretending to be judges say that if you want justice, we are the only place to go, and you're going to have to pay us. That is a perversion of our fundamental form of government. And it is my greatest grievance that they have the judiciary through the bar has usurped legislative power. Courts are courts of law or courts of equity. Our legislative houses are courts of justice. And if you go to any legislative house, they have hearing rooms. And hearing rooms are where trials occur. And we've seen that in the United States Congress with the impeachments and the inquiries that they've done in the United States Congress, that clearly the legislative houses are courts of justice. And so when we want justice, when we want the Constitution adhered to, when we have rights violations, when we have crimes committed under color of law, we do not go to the judiciary and pay them their court fees and pay them their attorney fees. We are to seek that justice through the right to petition for redress of grievance in our legislative houses. So grievance for redress of grievance. And grievance is the key word. And in Black's Law Dictionary, a grievance is either discrimination or it's oppression of a constitutional right. Courts of law are to go, when you have a tort, when you have, two people who have an issue at a question of law, did this person, create tortuous conduct, or if, did they violate state statute under criminal code? That's where you go to a court of law. But when you've got a question of justice, and justice pertains to oppression or discrimination, we go to our legislative houses. And these attorneys, since the 1960s, have perverted our legal system to say that we're the only place to go to. No, we must restore the power inherent in the people to go to their representatives. And the problem with this is that the legal profession has essentially taken control of two branches of government, and they largely have control of our legislative houses by having members of the court sitting in legislative seats. That's going to be a really tough nut to tackle, going after those legislative seats that I believe are unlawfully held. But still, we have got to get back to seeking justice in our legislative houses. And the way that we do that is through a petition, which is seeking favor, or it's through remonstrance, which is that formal written protest of unlawful conduct of government policy or government officials.
Right. And I noticed in the video, the clerk had read the information of the right of petition and the remonstrance. And was it another state senator, or was it an assemblyman who sponsored? He was the one who was able to allow your remonstrance to be heard.
That's a great question, because this is the why this right is not utilized today, and it's not done properly. So we see in this nation right now, because of George Floyd, tremendous protests across the country. They're useless because they're not doing it in the proper form, and the government has no duty to respond to people out in the streets, but they do have a duty, and their rules require them to hear and decide petitions and remonstrances. So here's the proper process: is you write up a petition, and this is not these stupid petitions where everybody just goes around and gets signatures and then they give them to somebody. No, you say, okay, I have a petition, I have all these signatures, but I'm exercising my First Amendment right, or I'm exercising my right under the state constitution to petition or remonstrate to you. And you give that to a member. That member has a duty required of them under House and Senate rules of order to file that with the clerk. And they do that by filing a brief statement. And they just say, I've got actual petitions that I have downloaded or that I have gotten from the Tennessee archives that show these back in the 1800s. And so the member would file a brief statement with the clerk of the House or the clerk of the Senate. And that brief statement just says, hey, I got a large number of people that want to petition or want to remonstrate about, X, Y, or Z. And then that brief statement is read on the floor. And then there is either an address, an oral presentation of that petition or remonstrance, or if it's a remonstrance, it's read. And then historically, we can see in the House Journal from 1831 that the full body they would say, be it hereby ordered, this petition is referred to the Committee on Propositions and Grievances. And those committees need to be restored if we are going to restore this republic. They had a committee on claims and they had a committee on propositions and grievances, and they no longer exist because our legislative houses have been perverted from the intent of the founders. Then the committee deliberates, they talk about it, and then they come back and make a recommendation to the full body. And then if there's any disagreement, there's discussion on the House floor or the Senate floor, and then they vote, just like a bill. Exactly the same process as a bill. This is the voice and the power of our people in our government. We do not just have to sit around and wait for them to file a bill on special interest. We can effectively, in this way, present our own bills or present our protest of unlawful conduct of the government. And we have to. Why do you think it's in the First Amendment, JR? What? Important right. They put it up there, right up there with free speech and freedom of religion. That's why and the Supreme Court of the United States in 1826, I think, that the right of petition is fundamental to a government, Republican in character and form. So it is fundamental to our government. That's where it comes from, consent of the governed and rule of law. Consent, and that rule of law comes from we the people.
Right. So, John, I want to make sure that the listeners and our audience understand that any one of us can write up a petition, a right of petition, and hand it to our state legislators, correct? And they have the responsibility to address that right of petition, correct?
Not responsibility, duty. And there's a big difference. A duty is a mandate. You shall. So in the House Rules of Order for Tennessee, Rule 15 in the House, and Rule 22 of the Senate, petitions shall be received and read at the table after a brief statement is filed with the clerk. They have a duty to file a brief statement about your petition or your remonstrance. And this is in the United States Congress, House Rules of Order number 12. A member of the House of Representatives of the United States Congress shall file petitions with the clerk of the House. So this right still exists in our United States Congress, or it's in our First Amendment, but their duty still exists in the House Rules of Order in our United States Congress. And I pray God, and I implore my people that we have to defend this right even more than we defend the right of free speech or the right to bear arms. The fact that we're having this conversation and nobody knows what the right of remonstrance or the right of petition is.
Yes.
Oppressed, actively oppressed by our government. And why do you think they oppress this right? It's because it's your most powerful constitutional right. And so as the men and women who declared independence at great risk of loss of life, we too must take our stand today to defend this right and restore what was, you said it in the beginning, this came out of the 12th century Magna Carta and was affirmed in the 16th century in the House of Commons and in our 1797 debates ratifying our federal constitution. It is our turn now, but we're going to do it lawfully and peacefully by uniting the people in common purpose to restore a fundamental right of the people that has been forgotten because it's been oppressed.
Right. So I want the people to clearly understand, John, that when proposed legislation comes out, each individual can write up a right of petition and send it to their representatives, and everybody should do that. That would be much more effective than going up to Trenton and standing in front of the state annex house with a sign on and using a bullhorn. It would be better if everybody wrote up a right of petition, respectfully so, done in a very cordial, professional manner, and giving the right of petition, giving your grievance, giving your opinion on why the proposed legislation is incorrect. This is what we should be doing as individuals.
Absolutely, and not just as individuals, but you go find like-minded people and you get many, many signatures and you say, this bill is in violation of the New Jersey Constitution or whatever state you're in. This bill is in violation of the Constitution and you can't do it. And here's why it's unconstitutional. Now, the power of that is in the publicity. And I don't know New Jersey, but in Tennessee, we have live stream recorded proceedings of all legislative hearings, as well as all chamber meetings of the full body. Mm-hmm. They're live streamed and recorded. And so if they properly read these petitions or present that address, then you can take those videos and spread it out to the people and say, these guys are in violation of the Constitution. And it's another case that I like. I think it's Pacific Telephone and Telegraph versus Oregon. The crucial prophylactic aspect of justice cannot occur in any dark corner or in any covert manner. And that is why we need to get this, because the courts are all star chambers. You know, they don't record, they will not live stream because they want our courts, state and federal courts, including the Supreme Court of the United States. They don't want cameras in there because they don't want you to see their corruption. But our legislative houses, many of them, and I don't know New Jersey, but many of them have put in cameras because that is the crucial prophylactic aspect of justice is the publicity. That
Yes.
being able to say, here's what happened, here's who said what, and here's the evidence of it in video.
Yeah, tremendous accountability in that regard. Now, John, I found it fascinating that your remonstrance wasn't a petition to the legislature, the legislative branch since 1850. Is that correct?
Well, two parts here. There has not been a petition since the year 1850. My remonstrance, and in my remonstrance, I am asserting my Article 1, Section 1, unalienable, indefeasible right to reform the government. I do not believe that has been done in the history of this entire nation, where any citizen or politician has asserted their unalienable, indefeasible right to reform the government. So it's the first petition since 1850, but it's the first remonstrance demanding reform in the history of this country.
Right, and wasn't it over 100 pages, your petition, and yet you had 600 different historical references, 600 pages worth of historical references to back it up?
I have, the actual remonstrance was 72 pages, and there are 700 pages of appendix that go along with that. That is all the proof and evidence that they're in violation of the Constitution.
Amazing. And so it takes work to do what we need to do. It takes research. It takes good quality writing.
No, I got to share this with you. It does not.
Okay.
I'm gonna share this, and hopefully I can find this on my screen real quick. I'm gonna show you a. Can you see my screen?
Yes.
Let me see if I can find this really quick. Yeah, early petitions. The image is a little large here. I pulled this from the Tennessee archives. So this image will come up in just a second. This is a petition. Sure. Say again? No,
very good. Good information.
This is a petition that was filed in the year 1801. They've got it notated in the top right. I don't know if you can see that. It was the second petition of the year 1801. Yes. And it says, to the Honorable General Assembly of the state of Tennessee now sitting, whereas your humble petitioner humbly showeth. And so this is the entire petition right there. And all it is, this is all a petition or a remonstrance is it's a statement of facts. It's the argument about why it was wrong and the redress that you want. That's all it is.
Simple. Very simple.
Very simple. And that's all it is supposed to be. This complication of the process that you're talking about, that is the perversion of our legal system by our corrupt judiciary and legal profession that has twisted and complicated the law to make it so that the common man cannot seek justice without going through them. And it is wrong.
Yes.
It is a tearing at the fabric.
Absolutely.
I have a couple on here. This is another petition from the year 1820. I love the script that they did. And here you have, you know, General Assembly of the Tennessee, greetings. The undersigned, your petitioner. And there were hundreds of them filed every year, JR. Every year. And this is the one, let's see. This one here. This is the 1831 House Journal. You can see, I pulled this from the Tennessee archives. So here's a petition of Alan Jack praying for divorce. And then you can see ordered that said petition be referred to the Committee on Divorces. Here's one, Hardin presented a petition of Nolan praying the passage of an act to hawk and peddle. Ordered said petition be referred to the Committee on Propositions and Grievances. These were very, very common back in the 1800s. And as you mentioned earlier, because of the Civil War and all of the petitions on slavery, we forgot this right. And then, after the Civil War, we went through a period of healing. And then we got into the roaring 20s where everybody's out partying and having a good time.
Right.
And then and then we got into, World War I, World War II, and it just happened that we forgot what was fought for and paid for in blood. And so now we have to restore this right. This is our duty, because if we don't fight, this is our last chance right now. If this does not happen, and I think probably under our current presidential administration, if this doesn't happen now, I don't think it's ever going to happen, and the republic is going to be lost forever.
Very, 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 very true. And the audience out there can go to your website, which is We the People 50. It's WeThePeopleV50.com. And John is on YouTube. You're going to want to listen to the videos and watch these videos, get more informed. And I thought it was very interesting on the website, John, that you put up under the proper form of government, quote, our government was formed on the concept of checks and balances to prevent one branch from becoming too powerful. Today, there is no check of one branch over another. Of our judiciary and judges in Tennessee routinely violate the right to a fair and impartial court, due process, if you will, in bias and sometimes corruption. I am working hard to restore accountability and proper judicial oversight as provided for our beloved Tennessee Constitution. You'll find that on the website.
This is a fundamental breakdown, and I implore you in New Jersey and whoever is watching this, this is the fundamental breakdown. If we are going to restore this republic, there are two things that have to happen. We have to restore the right of petition by address or remonstrance. That has to be restored. If you don't have a voice, you can't be heard. And the other thing that is essential is we have to restore fair and impartial courts. And we cannot have fair and impartial courts without the check of one branch over the other. And this this started in the 1960s. Up until about 1949, we had pretty good justice in our courts. And by 1960 is when they created the time is money concept, where attorneys start billing by the hour. And that's where the breakdown occurred. So they started complicating rules of procedure. They started complicating the process to make less what laypersons could do for themselves. And gradually, they started corrupting the courts. The next progression of that was that the judiciary, through its bar members, infiltrated our legislative houses and started enacting statute to benefit themselves and to create new torts. Is a lot of what they're doing in the legislative houses is they're introducing new product lines through legislation to benefit them, so the attorneys get paid money. And then the natural, unfortunate progression was rights violations and vexatious litigation. And that's where, it's gotten really bad. And so that happened in the 1970s. It got really bad. And so the judiciary, being as gracious as they are, they said, well, we'll provide oversight of ourselves. And they created all of these judicial oversight agencies across the country. And they said, don't worry, the fox will watch the hen house and we'll make sure all the chickens are safe. And that is where things turned really bad. In Tennessee, it was 1970. They created the Tennessee Board of Judicial Conduct and started providing, self-government and self-oversight. But you just got, corrupt attorneys in black robes protecting other corrupt attorneys in black robes, and there's no judicial oversight. And so this is essential, that we must restore objective judicial oversight in our legislative houses with that publicity that I talked about, that people can see what's happening in the legislative houses, that you go in there and you say, this judge, this attorney in a black robe did this, this, and this, and it's wrong, and here's why. And are you going to impeach him? or are you going to do nothing? Are you going to aid and abet? Are you going to forsake to defend the Constitution and my constitutional right of due process? And when that happens, the legislative houses are going to have no choice but to restore oversight. So that's the two things. If we hope to restore the intent of the founders and a constitutional republic, we have to restore the right of petition by address or remonstrance, and we have to restore objective judicial oversight. If you don't have the voice, you cannot complain. And if you don't have fair courts of law or fair courts of justice in the legislative houses, we can just kiss the republic goodbye. And I think where we are today, this is our last chance under this president. And with the work that I'm doing, it ain't going to happen again. This is our last opportunity to save the republic.
Right. Well, hopefully, and I certainly anticipate there are listeners out there and citizens in New Jersey and Tennessee and elsewhere who are listening to this conversation, and they're being motivated. And your passion, John, clearly comes through. I have that same passion, and it's just this is something that needs to snowball. That we need to get more and more people involved. We need to give people the confidence that they can write these petitions, that they can have a voice again. We need to hold our judiciary accountable. We need to hold our representatives accountable. And before we go, I'd like to talk about a couple of issues. One of them is your writ of certiorari that went before the Supreme Court a couple of years. Tell the audience about that a little bit.
Well, there was a bad actor judge, and there were several bad actor attorneys, and I brought a RICO, which is racketeering case, against the attorneys, and then I brought a 1983 case. That's 42 U.S.C. Section 1983. Any person that deprives a constitutional protected right is subject to civil suit. And so I took the judge. I only wanted the federal court to order this judge to uphold the right of due process. I didn't want money. I just wanted to follow the law, and the law is the Constitution, and the Constitution says you have to give due process. That's all I wanted. I spent thousands of dollars and incredible amounts of my time, and what I found out is that the Supreme Court of the United States is also corrupted. In that case, I evidenced the corruption of the Sixth Circuit and the Middle District Federal District Court in Tennessee, where they violated their own rules, violated United States code, and did not provide due process. And the Supreme Court of the United States concealed 14 of the 17 appendixes that I filed in the Supreme Court of the United States to conceal judicial misconduct of the lower courts. And I also filed, pursuant to 28 U.S.C. Section 455, I filed a motion to disqualify all of the Supreme Court justices, every single one of them, or in the alternative, affirm their impartiality. Tell me you're fair, and that you're going to decide this case impartially. And when there's a motion to disqualify, they cannot issue any rulings until they answer the motion to disqualify. And the Supreme Court of the United States ignored. They did not grant, they did not deny, they ignored my motion to disqualify. And that's docketed. And I had to fight the clerk of the United States Supreme Court to have that motion to disqualify docketed. But it is on the Supreme Court website. You can see it on there right now. And they did not answer that because they had no answer. And the argument is, if anything was working, any kind of judicial oversight, corruption in our courts could not occur. And my complaint is that because our highest courts will not uphold the Constitution, when a judge or an attorney is brought before them, they're aiding and abetting, and they are guilty as principal, that it is their fault that we have this corruption in the lower courts. It is the fault of the Supreme Court of the United States that the corruption in the lower courts is occurring because they will not do their job. And we saw this with Gorsuch. He was having a discussion with Senator Sass about his appointment to the Supreme Court of the United States. And Gorsuch said, any attack or criticism on a judge is an attack or criticism of all the brothers and sisters of the road. And I quote, brothers and sisters of the road. That is a fraternity. Mm-hmm. That is a fraternity. Mm-hmm. And they all look out for each other, including in our highest court. And so the only solution is if we restore judicial oversight outside the judiciary and we restore the right of remonstrance. That is the only way that we will have justice. I don't discourage going to the courts, because in the courts we create a record, and that record will be heard someday. At some point, there will be accountability. You can see what's happening in this country today, that people are dissatisfied to the point of outrage and protest. Yes. And so we are at a tipping point now. And I believe in my heart that this right is going to be restored. Justice is going to be restored. The republic is going to be restored. And I'm not going to rest until that happens. But we're going to do this. We're going to do it peacefully and lawfully.
Yes. And what you're describing is, the constitutional Republican movement. And I've talked about this over here, and you've already begun talking about it in Tennessee years ago. And that's the fact that we want to preserve the structure of the Constitution. And that structure is based upon the separation of powers. And that's exactly what you've talked about with the proper form of government. We talk about the purpose of government. So really, it's the constitutional Republican movement, John, that has to move the right of petition back into the minds of the people. The idea of the right of remonstrance, constitutional Republicans have to take this message and inform the people of what they have not known. They've never known before. And we do have challenges as constitutional Republicans. Now, we have cultivated a very good relationship with the state GOP. They're listening to us. They understand that we're an educating organization. We want to inform the people about civics. We want to bridge the gap there, the knowledge gap that has been developed as a result of taking civics and American history out of our schools and our universities. So we have a good relationship. We've started it, but yet we still have challenges because we are looked upon as outsiders or the fringe, and we want to be brought to the table and talk about a little bit in Tennessee where you're having to go through as a state senator candidate running as an independent constitutional Republican, and how important it is for the Tennessee GOP to bring you on board and understand what a great leader you are and what a great representative you would be.
Well, there's several in the GOP that appreciate the courage that I demonstrate, and they're with me and on my side. But the party is largely controlled by the judiciary and lawyers, and so they very much oppose me because I want to reform them. But I want to talk on this because this is really important about restoring the Constitution, and I think very few people understand the profound importance of our state and federal constitutions. Our founders went through the most horrendous corruption under the British Crown, and they were philosophers. They studied the forms of government, and they tried to establish for us everything that we needed to keep all of that from happening again. And they did a fantastic job. I mean, absolutely amazing work. I could tweak it a little bit, but man, there's just not much that needs to be done to the state and federal constitutions. They're so well prepared to protect against corruption, to protect the rights of the people. And very importantly is, we're the only republic that has the separation of powers with two legislative houses, one representative Yeah, that bicameral legislation is essential, and it is what preserved this republic for a very long time. But we've lost that because a lot of them are all
Yes.
in collusion, and the bar and the judiciary are largely controlling a lot of it. And the Bill of Rights has been absolutely, completely ignored and no longer protected now, and oppressed, considering that nobody knows what the right of petition by address or remonstrance is anymore.
No question. No question.
You know, and this garbage that we hear, that the Constitution is a living document, has to be interpreted. Yeah. Hogwash. The Constitution is not a living document that you can change at your whim. No.
That's right.
That it says in I think it's Article 6. I might have it mixed up. The Constitution shall be known as the supreme law, and
yes,
that's
supremacy clause, Article 6.
The law is not a living document. The law is the law, and it shall not be violated. And the Constitution is our supreme law. So this hogwash that these fools pretending to be judges, who are just attorneys in black robes, that is how they pervert us, is they plant these seeds. They say we're a democracy. Get out of here. We are not a democracy. We're a republic. And a republic
Constitutional republic.
It offends me, JR, that they say that it's a living document. No, it's the same law.
Yeah. And John, what we've talked about, the Constitutional, New Jersey Constitutional Republic, is we go back to the first paragraph of the Declaration of Independence, and we have brought the idea, the discussion back on the laws of nature and nature's God. And the laws of nature don't change. They're predictable. This is why we know the sun is going to rise in the east. It's going to set in the west. We're the gravitational pull of the planets, everything, the distinctiveness of human beings as being creatures very unique from all the other creatures of the world. All of this has the laws of mathematics, the laws of economics, all of these various laws, the laws of gravity, so laws of motion, all of this is indicative. And the founders understood this. And the people who believe in a living constitution and law being an object of relativity, this is why we've gotten into such trouble, because we've gotten away from the concept and the idea of the laws of nature, nature's God, and their permanence and their predictability and their perpetuity. So it's exactly what you're saying as well.
Yeah, and you're exactly right, and actually that's insightful for me, and I'm gonna use that because it does say that in the Declaration of Independence, based on God's law and the law of nature, and you know,
and that's what the founders, and John, that's what Jefferson was looking to substantiate this Declaration of Independence. He was looking to God and the laws of nature and the self-evident truth that all men are created equal, which is again another part of the laws of nature. He was making his petition, if you will, to God for defending the right to declare independence from Britain. He wasn't going to King George for permission, or another king or another empire. He was going directly to God and the laws of nature and nature's God in order to do that.
Yeah, Thomas Jefferson is one of my favorites, and you know, talking, you know, more and expanding about what happened with the judiciary. Thomas Jefferson, 1821, in a letter to C. Hammond, this is on the National Archives. You can pull it off of there, and he said the dissolution of our federal government lies in the power of the judiciary, an irresponsible body working like gravity, by night and by day, getting a little today and a little tomorrow, until all shall render powerless the checks of one branch over the other, and shall become as venal and oppressive as the government from which we separated. He predicted exactly what we're seeing today in 1821, because this corruption is timeless. It has been happening since biblical times, we see these attorneys and lawmakers perverting, but our founders protected us against all of that, in our
Yeah.
constitutions. And the only thing we need to do is, and it's not an easy thing, is we have to educate the people about the importance.
Yes.
We have to educate
That's right.
the Constitution, and
Yeah.
through that, about why it's important and what's in it, and then through that, force the government to restore or come back within the chains or the provisions of the state and federal constitutions.
Right. And John, the founders understood that man himself, man's heart is desperately wicked. And that they understood that that is part of a law of nature, that man's human nature. We talk about a human nature. A human nature is depraved, it's corrupt, it's selfish, it's self-seeking. The founders knew that men would make up a government and that they would bring all that human nature in view. And that's why they were so brilliant in breaking up the concentration of power, which happens as a result of envy and covetousness and selfishness. And they understood they had to break those different bodies, those different branches of government up. And they very much relied on Newtonian principles of force working against force. Whereas it all got changed with the progressive movement, who believed that, well, Wilson believed, how can something that's living work against itself? It has to have everything coordinated and everything pieced together. And they basically denied the law of nature. They denied man's human nature, thinking that man is a blank slate and that he can be programmed and engineered to think and to do what he's supposed to do. And the founders, of course, were much more accurate in their understanding of human nature than the progressives.
And and along that line, here's the brilliance of them. And I think I shared this with you on the phone the other day. Article 4, Section 4 of the United States Constitution says that the United States shall guarantee every state a Republican form of government. And nobody knows, like, what does that mean? Well, it's actually pretty easy if you do a little research. Edmund Randolph was a lawyer from Pennsylvania, and he was arguing the original language came from James Madison. And the original language for Article 4, Section 4 was the United States ought to guarantee a Republican form of government. And Governor of Virginia objected. They had some more debate, and they came out shall. And so shall is a legal term, and it creates duty. So the United States has a duty to ensure that every state has a Republican form of government. And Edmund Randolph said, no state ought to be able to transform itself into a monarchy. So we can clearly see they're talking form of government here. So monarchy is rule of one. And we know from the founders that they did not like democracy, because democracies, the Roman Republic, democracies have always failed throughout history. Greece was the same thing. Democracies have always failed. So they wanted, and here's a perfect example, our electoral college. Our president is not elected by the many, he's elected by an electoral college, because the founders knew that people are easily deceived and that rule of many or a democracy isn't going to work. And if we were a democracy, then every bill that goes through every state general assembly, every bill that goes to the United States Congress, let's put it out to everybody, because we certainly got the technology with the internet. Let's let everybody vote on it and let true rule of the many occur. But they ain't going to do that because we're not a democracy. And so, obviously we're not an oligarchy. We're not going to accept rule of the few. So who's the ruler? And it's rule of law. And that's where that comes. So our ruler is the law, and the supreme law is our Constitution, and our Constitution is ratified by the people. And so we are our own rulers, and that comes from Christian principles, that we were made priests and kings.
Self-governance.
Oh, exactly. And then, the other parts to that about a Republican form of government, according to early 1800 Supreme Court opinion, is fundamental to that is the right of petition. is fundamental to a government Republican in character or form, and a government that adheres to its Constitution is a government that is Republican in character or form. So rule of law adheres to the Constitution and upholds the right of petition. In other words, a government of the people, by the people, and for the people, which has been around a very long time before Abraham Lincoln as well.
Yeah. Outstanding, John. John, I want to wrap it up, but please tell the people when is you're not running in the primary, correct? You'll be on the general ballot in November?
Right, I'm running as an independent, so I will not be in the August primary, although feel free to write me in if you're watching from Tennessee. But I will be on the November ballot. And I intend either in 2022 or 2024 to seek statewide office and try to bring better change and faster reform through statewide office.
Great. And you're running as a constitutional Republican, which is what you are by nature, and everything that you're expounding. And we're very proud of you. And I appreciate our relationship. And I want to get together soon. I want to have another program, another virtual conversation with you, because I really think there are a lot of people who are going to be energized and galvanized by this particular conversation today. And we need to follow through and to keep talking about the right of petition and remonstrance. So I want to thank you, John. And anything else you'd like to say before we end the show?
No, but I want to thank you for taking this time with me and having me on and sharing this with the people in New Jersey. We need to keep finding ways to educate the people and spread this around. And one thing I like to end on, there's a 87-year-old woman who is my spiritual advisor. She's a strong Christian woman. And she guides me a lot, and she really gave me renewed the meaning of the words "in God we trust" for me, and so I always like to end on that Godspeed to us all, and in God we trust, and in Him we will find the right answers.
Outstanding, John. Thank you so much for today. Let's do it again soon. We'll be in touch. And I want to thank everyone for listening today and our audience. Please share this video, share this conversation. It's very informative in nature. I'm sure most of you are very enthused by what you heard, and share it with others. And just remember that as New Jersey Constitutional Republicans, as Tennessee Constitutional Republicans, we believe, as Lincoln said, liberty and justice for all. Thank you and good night. Thank you, John.
Thank you, sir.